Hello and a warm welcome to All This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court has ruled that a government employee cannot claim promotion as a matter of right, and no specific criteria have been prescribed in the Constitution for the same. A three-judge bench of CJI Chandrachud, Justice J.B. Pardiwala and Justice Manoj Mishra observed that in India, no government servant can claim promotion as their right because the Constitution does not prescribe criteria for filling seats in promotional posts. The legislature or the executive may decide the method of filling vacancies to promotional posts based on the nature of employment and the functions that the candidate will be expected to discharge. The court opined that the legislative and executive can frame promotion policy as per their will, and the same cannot be contested in court except if arbitrary or violative of fundamental rights. The question of the National Financial Reporting Authority's NFRA's investigative powers over statutory audits of business done prior to the watchdog's creation in 2018 is finally getting settled. The Supreme Court in March and then in May dismissed two appeals against tribunal order that upheld the audit watchdog's retrospective powers over audits. According to an assessment by the NFRA, this development has reinforced the watchdog's jurisdiction, including for the period before its creation in October 2018, a person with knowledge of the regulator's view said. This assessment is based on a fundamental principle of law called the doctrine of merger, which implies that only one operative order can govern a particular subject matter at any given time. The doctrine also seeks to preserve the hierarchical structures of courts and tribunals. The apex court's decision not to intervene in the tribunal order is significant because it also seals the fate of other challenges to NFRA orders pending in a few high courts. In a landmark decision, the Supreme Court, comprising of Justice Surya Kant, Justice Dipankar Datta and Justice Ujjal Bhayan, have upheld the land acquisition done between 1957 and 2006 by the Delhi Development Authority, Delhi State Industrial and Infrastructure Development Corporation, East Delhi Municipal Corporation and Delhi Metro Rail Corporation for public infrastructure projects. The Delhi government had initiated the land acquisition process under the Land Acquisition Act 1894 for the planned development of the national capital. The beneficiaries of such acquisition process were various state entities such as the DDA, DSIIDC and DMRC, who needed land for different projects like housing schemes, industrial areas, flyovers and Delhi Metro. The Supreme Court has rejected a petition filed by a woman seeking permission to terminate her over 25 weeks pregnancy, but refrained from making public the reasons for its decision to protect her privacy. A vacation bench of Justice Abhay S. Oka and Justice Satish Chandra Sharma pursued a report filed by the All India Institute of Medical Sciences, AIIMS, Delhi, which was asked by the top court last week to ascertain the physical condition of the woman and her fetus. Under the Medical Termination of Pregnancy (MTP) Act, aborting a fetus that is more than 24 weeks old can be allowed only in cases of substantial fetal abnormality as diagnosed by a medical board and if an opinion is formed in good faith for the purpose of saving the life of the pregnant woman. Now let's have an overview of high courts. The weight of the blotter paper considered a neutral substance must be considered when weighing the quantity of the offending drug, the Karnataka High Court has ruled. Blotter paper is a carrier material for psychotropic substances LSD. These blotter papers are ingested with LSD and therefore it forms an integral part of the ingestion by the user of the same, Justice S. Vijayajit Shetty said. The court refused to quash the proceedings in the NDPS case. The court noted that although ganja gummies were seized, they were not of commercial quantity. The dispute concerned the quantity of LSD. The seized LSD tested positive in the FSL chemical examination, but the quantitative and qualitative test report is still pending. The Madhya Pradesh High Court has ruled that a marriage between a Muslim man and a Hindu woman was not valid under Muslim personal law. The court also dismissed a petition for police protection to register an interfaith marriage under the Special Marriage Act 1954. Justice Gurpal Singh Ahluwalia said that the marriage between a Muslim man and a Hindu woman would be deemed as an irregular marriage and under Muslim law, even if they are married under the Special Marriage Act. As per Mohammedan law, the marriage of a Muslim boy with a girl who is an idolatress or a fire worshipper is not valid marriage. Even if the marriage is registered under the Special Marriage Act, the marriage would no longer be a valid marriage and it would be an irregular or fasid marriage, the High Court said. In a major ruling, the Delhi High Court has ruled that a right to be heard given to a victim or complainant in a state case cannot be uplifted to a right to be impleaded in a criminal revision. A single judgment of Justice Naveen Chawla observed that the right of the victim to participate in the trial and proceedings emanating from there, though recognized and important, it is not the position where the victim replaces the public prosecutor. The right would remain subordinate to that of the public prosecutor, and therefore, where the victim applies for hearing of a revision petition, while the victim must be heard, there is no mandate in law to implead the victim as a party, the court said. The court also held that while the victim complainant has a right to be heard in the revision proceedings, such right does not upscale itself to the right to be impleaded in the said criminal revision. The Bombay High Court has held that TDS, tax deducted at source, is not applicable on transit rent or hardship allowance paid by developers to the owners or occupants of a project under redevelopment. The court clarified that such transit rent is not to be considered as revenue or income. Consequently, there is no question of TDS as this is not income in the first place. Even though redeveloping a project or building brings lots of benefits, the tax implications of the transit rent has been debated for long. The owners and the occupants of a building which goes for redevelopment have to hand over possession of their property to the developer. To facilitate this, the developer provides transit rent or hardship compensation for them to relocate to a temporary alternative accommodation. Income tax authorities have seldom considered this payment as taxable income. However, developers have played safe and treated transit rent as revenue in the hands of the occupants and deducted TDS from the amount paid. Naturally, the owners and occupants objected to this. The Karnataka High Court has ruled that sub-registrars cannot refuse to register a document based on pending dues owed by the borrowers to the Income Tax Department. The court issued this ruling while allowing a petition filed by a purchaser of land auction by Canara Bank. The petitioner argued that the auction proceedings were conducted under the Securitization and Reconstruction of Financial Assets and Enforcement of Securities Interest Act 2002 SARFAISI Act, which takes precedent over any other law. He contended that the pending dues with the Income Tax Department were not a valid reason to deny the registration of the sale certificate. The government countered the argument, saying income tax dues are statutory obligations and must be cleared by the borrowers to ensure the property is free from encumbrances. It submitted that the sub-registrar will not register the property if it is not encumbrance-free. The court reviewed the provisions of the Registration Act and rules, noting that the sub-registrar does not have the jurisdiction to refuse registration of a document unless there is a violation under Rules 171 of the rules. Moving on to international news this week. Donald Trump has become the first former US president ever convicted of a crime after a New York jury found him guilty on all charges in his hush money case months before an election that could see him yet return to the White House. The jury found him guilty on each of the 34 counts of falsifying business records to hide a payment meant to silence the adult movie star Stormy Daniels. He could, in theory, be sentenced to 4 years behind bars for each count but is more likely to receive probation. The 77-year-old Republican, who was released without bail, is now a felon, a historic and startling first in a country where presidents are frequently described as the most powerful man in the world. Trump, however, is not barred from continuing his battle to unseat President Joe Biden in November, even in the unlikely event if he goes to prison. And he voiced immediate defiance. A court in Hong Kong has found 14 to 16 activists and politicians guilty of subversion in the Chinese territory's largest ever trial under the Beijing-imposed national security law. The judges, designed to hear cases brought under the 2022 security law, which does not allow jury trials, shared the reasoning for the decision in a 319-page document posted online. The group was amongst 47 people, including some of Hong Kong's most prominent supporters of democracy, charged over an unofficial 2020 primary to choose the Democracy Camp's candidate for a legislative council election that was later postponed. Many of them have been held in custody since they were arrested in a pre-dawn swoop in January 2021. China's deeply indebted property giant Evergreen has been fined Rs $576 million for fraudulent business practices, Beijing's financial regulatory body has said. Between 2019 and 20, Evergreen Real Estate falsely increased its revenue and profit by prematurely recognizing revenue, resulting in fraudulent issuance of bonds publicly offered on exchange of market. The China Securities Regulatory Commission (CSRC) said in a statement. It added that the firm had failed to disclose regular reports as scheduled, failed to disclose major litigation in arbitration as required, failed to disclose failure to settle debts due as required. In the end, we have miscellaneous news. Sikkim High Court has decided to grant menstrual leave to women employees for up to 3 days every month. The notification to this regard stated that their leave account shall not be debited on availing such leaves. The issue of mandatory paid menstrual leaves for women employees was much debated in this country recently after Union Women and Child Development Minister Smriti Irani voiced her opposition to the idea. A lawyer has moved Kerala High Court challenging Hindi and Sanskrit names given to the recently passed central laws. The central government has enacted the Bharatiya Nagarik Suraksha Sanhita, Bharatiya Nyaya Sanhita, and Bharatiya Sakshya Adhiniyam, which will replace the Code of Criminal Procedure, Indian Penal Code, and the Indian Evidence Act from July 1, 2024. The Hindi and Sanskrit names given to the laws violated the constitutional provisions that all bills introduced in legislative bodies and act passed by them shall be in English. The legislative intent of the constitutional provisions was to bridge linguistic barriers and promote unity and understanding among the diverse linguistic groups in the country, he argued. The naming of the acts was a classic case of linguistic imperialism and went against democratic values and principles of federalism, he contended. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.